Hey, fellow Toolboxers. Welcome to episode number 296 of the Immigration Lawyers Toolbox podcast. Today, we're doing one of our fan favorites, which is reviewing federal court cases with Kevin A. Gregg, partner at the Kurzman firm and real stand-up guy. So, really happy to talk about that. Always very interesting learning about the case stuff, especially for someone who actually reads all the decisions. That's always really helpful. So, that's going to be what we're going to talk about today. And as always, talking about helpful information, check out the Toolbox magazine, the trade magazine, one of a kind, where you can learn about updates and real good, practice-based stuff. Check out back issues, new issues. Go to iltbox.com or immigrationlawyerstoolbox.com and check that out. Thank you for our sponsor, DocuWise, for supporting the magazine and the podcast for so long. DocuWise.com, your resource for practice management, not only the forms, but also all sorts of stuff about tracking time, translations, payment and fees, and all sorts of other new things that pop up every day in different languages they have services for. It's just amazing how much updates that are getting in that kind of software. Check it out. We also do interviews with the founder every quarter or so to see what new options are there. So check out the back catalog. We're going to be recording a new one pretty soon. That's DocuWise.com. And on my end, we train on marriage-based green card cases and fiancés. The new course has a fiancé course in it. It's going to be a lot of fun. If you want information, you're trying to get involved in immigration, you want to have a relationship with me in our office hours so you really get good at what you do, well, the trick is to, get the course. And so email me at info@immigrationlawyerstoolbox.com so you can live the dream as well. And, the following is not intended for individual legal guidance. Consult with an immigration attorney for your case. And don't forget to leave a 5-star review wherever you're watching this. Hey, Kevin, thanks so much for coming on the show again. Look forward to having our June case review? It's a little backed up with all the holidays and stuff.
It's the June case review. We are backed up because of AILA National and then some, God forbid, vacation on my part. But we are back for the June cases. And, take this in because, they're good cases. But, the Fourth Circuit is going wild in July. So, next month, it's going to be, all Fourth Circuit asylum cases and deficient NTA because the Fourth just is going nuts. Destroyed my week last week, a 9-case episode last week. But at least the Supreme Court is done. This is now the third year in a row that I've gotten through Supreme Court season, which is a dangerous season for me because we're adding another court, and the Supreme Court cases are never short.
No.
So I've gotten through my third Supreme Court decision and season, so I'm happy about it, which is one of the first ones I'm going to talk about. But people might not know, of course, we've never actually met in person. But so we got to meet at AILA National, so that was pretty special.
Yeah, it was great. And if people haven't caught the recording of yours, it's on AILA that they were talking on the panel and everything. It was good seeing you. It was brief, but it's good seeing each other in person.
Yeah, there'll be more of it now that the world opens up. It's the busyness, thank God for virtual stuff. I couldn't do half of what I did if not for technology.
I was talking with Angelo Paparelli. I did an interview with him an hour ago, and he started a group of business immigration attorneys 20 years ago. I'm like, how in the world did you do that? Because no one has time. It is before Zoom and stuff. Yeah. So we started small and we grew into it, and we made sure to see each other in person, all that kind of stuff. That's dedication, but you got to do that. These kind of small organizations where you be in person to support each other is really important. So, and we're so close too. I can't. We have to go to Florida to see each other, but I'll try to make my way down to San Diego. It's so nice over there. I'll bring the family. I'll say this. I'm gonna go on a little excursion myself to see Kevin and come back and we'll hang out.
That's right.
Good stuff. So
look, that's not my fault. I went to the AILA California conference in Los Angeles last year, and you didn't show up, so that's on you, man.
Well, no one invited me to come speak, and I was offended, to be honest. I'm in LA. It's right in LA. No one from the committee came and tell me to come. Okay, I'm gonna boycott it.
All right, fair enough. But I'm just saying, you knew I was going to be there.
That's true. So what kind of cases do we got this month?
We got to start with the Supreme Court. If nothing else, United States v. Texas, which I don't want to be, dramatic, but Supreme Court decided not to just tank humanity, at least in the immigration context. Can't speak for some of its other decisions, but United States v. Texas, it's all about standing, but really upheld a president's ability to exercise prosecutorial discretion through the Department of Homeland Security when it comes to immigration enforcement, which is a completely not extreme or novel position to hold. But yet there is a dissent. written by Justice Kavanaugh. So, one of those cross-party line things too. And it's essentially is saying that immigration prosecutors have the same discretion as federal criminal prosecutors, and that is they have the discretion about who to prosecute, who to detain, and who not to. And yeah, we're dealing with agencies rather than constitutional issues of criminal law, but I would like to think that the Department of Homeland Security officers also want to have justice as their core principle, as NEA USA would tell you is their core principle when it comes to prosecuting cases and exercising their discretion. So Supreme Court said that is possible, and they can do that, upheld the Mayorkas memo about enforcement priorities. Justice Alito wanted to say that because the statute uses shall, it seems, I guess, every non-citizen possible under the statute must be detained and can't get a bond and must be, prosecuted without any nuance. It's a world I don't want to live in, and not just because of immigration, but just because, they're human beings.
Yeah.
We're human beings. If you lose discretion and the ability to look at a whole person, then you just are a robot. That's not really the decision.
Yeah.
That's more of a rant. The decision's about standing. The Supreme Court said that Texas and Louisiana don't have standing to force the executive to prosecute, to do something, which is also not a very controversial position. The quote that I like that I said on the show, my podcast, was a telling indication of the severe constitutional problems with the state's assertion of standing is the lack of historical precedent supporting it. And they had nothing. There's the EPA decision. It was in Massachusetts v. EPA from Admin Law 101, where essentially, and I'm digging way back, but I think the states kind of forced the Bush administration EPA to start regulating carbon emissions in cars, but it was meaningfully different for the court, and I think that's a plurality decision anyway. Point is the states can't force the executive to enforce immigration law, at least in the prosecutorial discretion.
Immigration is a federal thing. It's one of those specific things, kind of like foreign policy or war and stuff like that. They can't tell the president to invade this or get involved with that kind of stuff. I didn't read the decision. I kind of make up my own armchair.
Yeah. Well, I mean, it's a bit. I think it's a bit less than that because depending on the decision, depending on how we want to frame it. But at base, we're just talking about agencies. Even though it's people, even though there's constitutional concerns. I mean, EOIR, DHS are agencies. So theoretically, all of these decisions coming out that permits these lawsuits and whittles down the administrative state, like what they just did in the Clean Water Act case, like what they did in the West Virginia case, also applies to immigration. And of course, next term, they're going to destroy the Chevron doctrine. So it all should apply. So it's not as maybe crazy to get states to try to get the federal government to do something with its administrative agencies. But to the Supreme Court, I think they saw this more as trying to get prosecutors to prosecute, and that you can't do.
Mm-hmm. Cool. Well, thanks. What else do we got?
Not that there's a lack of immigration prosecution going on in America anyway. Not that had anything to do with it. I was looking for some interesting cases too this time. And so there's Giron-Molina v. Garland out of the Second Circuit on June 20th. And to be honest, it's not so interesting legally, but it is about whether or not the Arkansas crime of abuse of a corpse is a crime involving moral turpitude. And the Second Circuit said it's not. Now, again, on this thread of me not actually saying what the decision's about, my initial reaction, my mom was actually visiting me at the AILA National Conference when this decision came out, and she's a listener of my podcast, and so I just started laughing and told my mom what it was about. Mom, you're going to hear this on Monday. But then I started thinking about it, is abusing a corpse, no matter what you do to the corpse, worse than literally any crime that involves physical harm to a living being?
Yeah.
I would argue it's not. I mean, the corpse is dead. Unpopular opinion, I suppose. That has nothing to do with what the Second Circuit was holding. This is a horrible case too. It looks like, and this was like Google research. The Second Circuit didn't get into it at all, but I think that it's like the non-citizen. This was the non-citizen's 1-year-old child. It looks like her abusive boyfriend or something like shook her baby, and then she freaked out and like put her baby in a closet. It's really like no one's arguing that Miss Giron-Molina had anything to do with it. Like it seems like she was traumatized twice, right? This happened to her with her baby, and then she's scared about the repercussions, probably immigration related, and then she has to deal with getting removed. I mean, the whole thing's terrible. I don't know. That's just an inference from how the decision was, but in essence, you can, under the Arkansas statute, you can abuse a corpse. I'm sorry, you can. Right. You can mutilate a corpse, or you can remove or disinter a corpse. And that's the one that I think was Arkansas said, look, the Second Circuit said, look, in Arkansas, you can like remove a loved one's body from a grave and not fill out the paperwork and put them somewhere else. And that would be a crime, but it's not morally turpitudinous, I guess. Or if floodwaters were coming to Louisiana, explained the Second Circuit, you could try to remove your loved one's body so like the floodwaters didn't, make the crypt float, as sometimes happens in like New Orleans. I don't know if everyone was ever prosecuted for doing those things, which is even more of the point. That's the realistic probability test, as I wrote in your magazine. If the crime can be convicted in that way, like you don't need a prosecution if the statutory text is overbroad. So interesting case from the second. If you want a really deep dive into the realistic probability test that I'm not going to get into now, got into it on my pod, obviously, is Portillo v. DHS out of the First Circuit, which is about firearms offenses and the antique firearm exception. Jennifer Klein, Susan B. Church, and Kathleen Gillespie, all-star team there, getting that big win out of the first. And that's the case to look at if you really want to figure out how to do this crimmigration realistic probability test stuff. That's a great win too. So won't get into it though. I'll be here all day. Before I get to my last case, you and I had talked about, though, what the Ninth Circuit kind of did this week in the Muñoz v. Department of State decision, which what happened this week is the Ninth Circuit decided not to rehear its Muñoz decision en banc. I think there were 9 judges who wanted to, but that didn't meet the threshold to rehear the case and decided again. I've been in touch with the attorney on the Muñoz decision. They believe there's a possibility it goes to the Supreme Court. They knew the en banc challenge was coming. I mean, who knows? It's that important of an issue because it's about the doctrine of consular non-reviewability, which is the bane of all State Department consular attorneys' existence.
Yeah,
I could be wrong, but I think the last decision, at least that I can remember, is Kerry v. Din, about essentially, if I recall, the Department of State says Miss Din's husband supports terrorism and doesn't have to explain why.
Yeah.
You can't sue the Department of State for denying a visa. It's essentially the doctrine of consular non-reviewability. But in the Muñoz decision, episode 128 of the Immigration Review podcast, the Ninth Circuit essentially said they have to give a facially legitimate, bona fide reason for denying, which is a small bar, but they have to do it timely. Like in the Muñoz decision, it seems like the consulate didn't tell Mr. Muñoz any real reason until like they sued in federal court.
Yeah.
And that was too late for the Ninth Circuit. At the end of the day, they said, like, we think you're a criminal because you've got gang tattoos. And by the way, we're not sure they're gang tattoos, that old thing from Central America.
Yeah.
But They didn't even say why. They just like were denying, or if they were saying why, it was so vague that it didn't cut it. And the most important thing is that, so then by the time the consulate told them a legitimate reason why, a bona fide, facially legitimate, possible reason why, it was too late. And you were already in federal court with full discovery, right? And a full, I guess, APA challenge to the denial of the visa. So getting over that hurdle of consular non-reviewability because the consulate didn't give a good enough reason quick enough, got full-on federal court proceedings. And that's the big deal of Muñoz.
Yeah.
It is an exception that can bore a big hole in this consular non-reviewability rule if the consulate doesn't act in time, if the Supreme Court doesn't overturn the Ninth Circuit in a petition for rehearing. I mean, in a cert petition. Now, does the Biden administration need to ask for cert? It does not. That being said, even if it doesn't, I'm sure, eventually there'll be another district court decision that'll go to the Ninth, that could go to the Supreme Court. So with the doctrine of consular non-reviewability being so pretty firm in Kerry v. Din, I would imagine this issue goes to the Supreme Court eventually. But for now, especially in the Ninth, we have this ray of light to challenge consulate denials in the Ninth.
So,
Ninth, yeah.
So, I mean, it's kind of a good or bad thing that the inbox didn't list, and it just keeps things as they are.
It's a good thing. It's a very good thing. Oh, yeah.
And do you know why some of the, like, I just read a synopsis. The Law 360 had an article I read about it, Alan Diamante, and I think it's his firm suing on it. Alan Diamante is a great local lawyer in Los Angeles. Is there a reason why some of the judges recused themselves? I was like, why are these judges recused themselves on this particular case? Did they hear it the previous time? Is that why?
I didn't.
Or, I don't know if you caught that. It was just the article mentioned.
I didn't catch it. I think though. I think that the judges on the panel recused from the en banc consideration. That wouldn't make sense, right?
Yeah.
But I'm not sure. That might be the reason. I'm not sure.
Speaking of this stuff, there's this part of INA 212, the admissibility statute, that I always found funny. So 212B says notice of denials. I'm
sorry, before you do this, you gave me no indication that you were going to be throwing statutes at me or that you were going to be sharing a screen. We have never shared the screen before. Look at this. Everybody see, look at this. Look at this. There's like 300 words on this screen right now.
It's INA 212. I have to actually, even though I don't even deal with it so that much, I'm constantly reading this, trying to figure out what the hell is going on with the statute. But because they mentioned that the embassy didn't have to tell these people. In 212B, it says, subject to paragraphs 2 and 3, if an alien application for a visa for admission to the U.S. or adjustment of status is denied by an officer, because the officer determines the alien inadmissible under subsection A, subsection A being all the different admissibilities that there are, the officer shall provide the alien with a timely written notice that A, states a determination, and B, lists the specific provision or provisional law under which the alien is admissible or adjustment of status. Okay, so why they denied it, essentially, let's say why. But then paragraph 2, it says the Secretary of State may waive the requirements of paragraph 1 with respect to a particular alien or any class of alien, admissible alien. So statute says USCIS has to tell you, but DOS could not if they don't want to. I'm like, it's always kind of weird. It's like, why does the statute exist if it gives them that loop open? And the third part says paragraph 1 doesn't apply to INA 212A 2 and 3, which is criminal statute, the criminal one and the security one. Security one, I mean, it's annoying that they don't always tell you because you're just caught. Why did they give us denial? It's confusing, but it's just a clear thing.
I think that what the Muñoz decision would say, even for the INA 212, A2A, II, a CIMT, something like that, you still have to at least cite to the statute.
Yeah.
You still have to say, I mean, I would have to go back to Muñoz from many months ago and look at the interplay. I'm pretty sure they probably talked about this statute, but I don't recall them discussing it. And so maybe something is missed because all of that is there. But I think the Ninth Circuit would say you have to say what the statute is and you have to give a fact. Yeah. It's a low bar, but you have to meet it. or you're in full-on federal court challenge.
You gotta give people something, even like it's just to leave people hanging like this is something. But I know they can always put them in admin processing forever, and that's a way to get out of doing this kind of
Yeah,
stuff.
you know, I get
Jurisdiction.
all worked up on Muñoz, but like state still holds all the cards.
States too powerful, too powerful when it comes to that stuff. Yeah, cool. I think you have one more case you wanted to share.
Yeah, just quick. You know, Ninth Circuit bias. Arizmendi-Medina v. Garland, published by the Ninth on June 7th. And, you know, this is about due process rights of non-citizens. It happened in my backyard in the San Diego Immigration Court. Essentially, you had a pro se asylum seeker who like came to court a couple times, and the immigration judge is like, you should have an asylum application filed at your next hearing. And then he hired an attorney just before that hearing, and the attorney showed up, and it seems like this was the first time that the attorney was informed that an asylum application was actually due that day, which is like every attorney's worst nightmare, right?
Yeah,
It's just horrible. And it wasn't even an individual hearing, it looks like. It looks like it was a master, which would make sense. That's when an asylum application would be due. And so then this attorney's there, and she's like, oh my God. And so she immediately asked for a continuance, denied. Then she asks, okay, well, we're at the beginning of the master, I don't know, 9 a.m. I'll come back in 3 hours before you're done with your master, and I'll have this asylum application to file. And the IJ says no.
damn.
And then she's like, okay, well, for the last, 8 years, EOIR has permitted window filings of asylum application. You don't even have to file it at a master anymore.
Yeah.
I'll get it to the window today. And I just like, no. Asylum denied, abandoned, deported. And the Ninth Circuit wasn't having that. And so when this decision came out, I sometimes like to, reach out to the attorneys who won it. And in this case, the attorney, because in this attorney was clear, this attorney had taken it from immigration court all the way up to the Ninth. Like, quite frankly, this is not what she thought she was getting into, right?
Yes, life.
Like, obviously. And here she has just been fighting this case. I don't think she did anything wrong, but like, this is something that would make me like nauseous. And she's been dealing with this for years. And I reached out to her, and she had been traveling that day, and she didn't know yet because she'd been traveling. And so like it's just like incredible, right? Like the range of emotions then that this decision did for her. I mean, that's the real world thing for the attorneys, much less the non-citizens. But here's some quotes. Like, the Ninth Circuit, quote, no delay at all would have occurred in the adjudication of the merits had the respondent been allowed to submit his relief application to the IJ at any time on that day.
You could do a nominal filing on these things, but I don't do asylum cases anymore. But you can have like a basic, the first 6 pages or something like that. That's all you need.
That's kind of to lodge it for employment authorization purposes, but that's not what this was. You did need a substantively complete application,
Okay.
and doing it in 3 hours before the master is done is not advisable. But like, you could have.
Yeah.
Quote, a myopic insistence upon expeditiousness will not justify the denial of a meritorious request for delay. It's a great quote. I like the good writing. I mean, filing deadlines are, and also, by the way, the Ninth Circuit didn't think the immigration judge was clear enough about the consequences to the non-citizen of not filing it on this day. But like, even if the IJ had been, like, to me, like, give the attorney, the attorney has just been hired. If you believe the attorney that they had no idea, they give them a day. You know what I mean? Like, maybe it's some of it is that, immigration judges are used to, some of the older ones are used to this framework where you had to file your asylum application at the master calendar hearing, unlike any other application, for reasons that I never understood. But that hasn't been the case for years. Like, you could file this at the window, you could file it online, like any other application. Like, why order somebody deported when they clearly just got an attorney, and that attorney is being quite saying that I'll file it in 2 hours, Judge.
Mm-hmm.
We can still keep the individual that you're setting for 8 months from now. So the Ninth Circuit wasn't having any of that. Very good case for continuances, the denial of relief, being kind to attorneys, all of the above.
How often do you reach out to the attorneys on the cases?
Not that often, actually. That I always give the attorney their props, but this one struck me, and I'm glad I did.
Now, I reached out to a couple people. For some reason, most of the time they like don't respond. I'm like, oh, you did some great work, congratulations, or something like that, and they don't respond. I was like, that's kind of weird. But yeah, it's yeah. I always go to read the now that I'm really involved in the field, trying to see who's doing what, and who the game changers are. Pretty frequently enough, the same names pop up a lot. There's like
Yeah,
there's
they do.
yeah.
Ben Winograd and Sang Yup Kim need to start paying me because I promo them so much on my podcast. But that's because they keep winning these awesome decisions.
Yeah.
I only give the props when the non-citizen wins. So, if you're getting your name said. The other problem that's unfortunate is that the Fifth and the Eighth, I think only those two, but maybe another one. The Fifth and the Eighth Circuit don't say who the attorney is in their day of decisions. So if you win in the Fifth and the Eighth, unless you email me, you never get your props because I'm not going to Westlaw to figure it out.
Well, Kev, thanks again for coming on the show. We'll probably be back in a few weeks to recap a new set of cases from July.
It's gonna be the Fourth Circuit episode next month.
Any travel plans, or are you staying at home reading Fourth Circuit decisions for the next couple of weeks?
Nothing, no travel that I can think of anytime soon. The wonderful day at World of WebEx. We won a 237A1H waiver in the Miami Immigration Court this morning, from my chair in San Diego. It's a great feeling, and I'm happy I didn't have to fly to Miami. What a world we live in. And yesterday I did a master calendar hearing in Boston from my chair in San Diego. All I had to do was wake up at 4 a.m. But
welcome to my world.
Right, well, yeah,
it gets easier the more you do
it. I don't know how you do that. I was useless for the rest of the day. I need my sleep.
You gotta go sleep early, and by the afternoon-ish. It's like it's me right now. I could do a podcast where you're doing all the brain work, and I'm just kind of like just listening. How often do you deal with 237A1H?
That's right. You wrote a whole book on 237A1H.
Unpublished draft book that's got
unpublished draft book.
Yeah.
Not so often. It's essentially the marriage fraud waiver, right? I mean, there aren't many other circumstances where you're in a 237A1H world, but we got a few cases on it. Scary stuff though, because I do think that if you have to, as you wrote the unpublished book, but you have to have otherwise been admissible, but for that fraud, as you know. And I think a good DHS attorney could maybe make a pretty good argument about why many people weren't otherwise inadmissible. Figure out some reason, if they did something else before they got to America, they have some conviction that's a CIMT.
Yeah.
If their marriage, is something going on with the marriage. I mean, it's a bit scary because it's a really favorable waiver, as you know, but like very narrow circumstances where it can be applied.
Yeah, it's pretty wild though. You just pick up where you left off, and your green card's valid as it was, and you file for NAT. So it's like, oh wow, this is like a crazy.
You can NAT right away, right? That's how I did it.
Yeah.
So the 5 years have been running on my guy for 15 years. It's just took forever to resolve.
What I find is like USCIS won't even NTA these cases too at the same time, which puts you in a weird. When it doesn't happen, is like I want to go to court to get the because if you have a good case, like well let's do it, just get out of the way, and you're not getting the NTA, and they've said you can't do that system of filing a fake asylum claim that's considered like malpractice. Now there's some court decision on that. So it's a funky place to be if you get stuck in that, but it's a very interesting statute.
I feel very strongly that you shouldn't be filing false asylum applications to get removal. The Second Circuit just tore into a attorney in New York last week on it. But I mean, first of all, if you're gonna do it like they did it in the Second Circuit decision, like at least put on a cancellation case once you're in court. According to the second, the guy asked 4 questions on direct. Like you're gonna put your client up in into the lion's den, and then I don't know.
I hear you. I hear you. It's always a messy maneuver to do. I mean, I never saw
Again, to be clear, because we're getting recorded, it's not just messy, it's like unethical and possibly illegal. Not what you
It was
do.
a nice circuit. Someone said, "Don't do." There was a 6 9 months ago. They said, "Yeah, you can't be doing this. Like, shouldn't do this." Like, there's a case on it.
If you get it right, you get a frivolous aside, and putting aside the ethical stuff. Like if you get a frivolous, first of all, 42B cancellation is very difficult to get. But if you get a frivolous asylum finding, which is a very easy thing, I would think, to make when you just withdraw that asylum application and then apply for cancellation, you're barred from everything forever. It's crazy to play that game.
Sure. I mean, there's a myriad of people in the 2000s who fell foul of the notarios and some lawyers. It's like, let's get you a work permit.
Yeah.
I
In
have
LA.
every once in a while. Yeah.
In LA, where you are.
Yeah, big that these pop up from like, you have a great case. They're your child's a parent of U.S. citizen case. I'm like, oh, wait a minute, you filed asylum in 2000? Yeah, the guy said get work permits. I'm like, oh no, that's terrible. And then we have NTAs that they didn't know about. Just a mess. But good to see you, Kevin. I appreciate it, bro.
Until next time.
Catch the Immigration Review podcast wherever podcasts are found. God bless. Talk soon.
You didn't do your DocketWise promo. Do you want to do it now?
I had an intro at the beginning.
You
didn't hear. I don't want to bore you with my intro, so I record it later. Thanks. Good to see you, bro.
Yeah.
Have you ever felt that the road to establishing a successful immigration law firm is riddled with unexpected obstacles and setbacks? I've been there, and I'm here to tell you, you are not alone. Picture this. My wife, then girlfriend, and I had just landed for a vacation, only to be greeted by a voicemail that changed everything. In an instant, once the plane landed, she lost her job. The very one job that was supposed to support us while I launched my own solo immigration law firm. Suddenly, our financial cushion vanished, and I was thrust into the high-stakes world of entrepreneurship with no safety net. Despite a slow start and a discouraging lack of leads and referrals, I remained determined to build a law firm that provided a 5-star client experience. After countless hours spent researching, watching, and implementing marketing strategies with mixed results, I eventually began to see my firm's revenues not only surpass my previous revenue and salary as an associate, but double it. Today, I run a successful law firm with a team of associates and support staff, and I'm the proud founder of the Immigration Lawyers Toolbox magazine, podcasts, courses, workshops, and more. But my journey wasn't easy. I made many mistakes, wasted time and money, and wished I had a mentor to guide me through the challenges. Although I was fortunate enough to find a few peers who offered support, I couldn't shake the feeling that there had to be a better way. That's why I decided to be the change I'd wish I'd seen. This month, I'm thrilled to announce the launch of the Immigration Lawyers Toolbox private mentorship and peer group. This exclusive group is designed to bring solo and small firm practitioners in a monthly, private, and intimate setting to openly discuss business strategies, share successes, even exchange invaluable tactics that they wouldn't share anywhere else. By joining this premium group, you'll not only benefit from my hard-earned expertise, but also forging long-lasting relationships with like-minded professionals who are committed to elevating their practices. Space is limited for this game-changing opportunity. If you're ready to make a real, lasting impact on your business, simply email me at info@immigrationlawyerstoolbox.com. Again, that's info@immigrationlawyerstoolbox.com. And I'll send you all the information you need to get started. Don't miss this chance to transform your immigration law firm and reach new heights of success.